Ready.
I want to welcome everybody to our Zoom presentation today. I'm Jackie McFarland. I'm a case manager at the Fort Bend Center for Independent Living. We're a nonprofit agency that advocates for people with disabilities. Today's presentation on guardianship, I expect will provide a lot of good information. Allison Skaberg from Consolidated Planning Group is here, and Lisa Wilson from Hayes and Wilson law firm is here. As your child approaches 18, you may want to consider a guardianship. If you have any concerns around their new right to vote, their new right to get married, their new right to decide where they live, their right to consent and refuse medical treatment. This presentation will address how to determine if guardianship is appropriate for your child, our alternatives to guardianship, and the procedure for obtaining a guardianship. Special needs financial planner Allison Stauber. She is a passionate advocate for special needs community. She's a parent of children with special needs, and she understands that world. For more than 25 years, she's worked with families to plan for their lifelong needs and a family member with a disability. Lisa Wilson from Hayes and Wilson Law Firm has been practicing law for 25 years in estate planning, probate, and guardianship, with a special emphasis on special needs planning. She's graduated of the University of Texas at Austin and of the University of Houston Law Center. I want to welcome both of you to the Fort Bend Center. And Allison, I'm going to hand it off to you.
Thanks so much, Jackie, for having us again. It's great to be back with you. So as she said, Allison Skaber, Consolidated Planning Group. For those of you that are joining us for the first time, we're glad you're here. We really try to put out a lot of educational information for families with special needs. Consolidated Planning Group is a holistic special needs financial planning firm, and we're here to serve this community. We serve all over the state of Texas and many other states as well. But guardianship, that is just it's a big word. It's a big word that we hear about all the time. And it's something that we don't have to think about for many, many years. For just about 18 years, we don't have to think about guardianship and what that means and what we have to do. And then what happens is we come to this point in our life, of this transition point in high school years, and you think you've got a long time, and then it flies by, and then you have all these things on your list that need to get done, that need to be evaluated, or what, and you need to figure out what you got to do. So today we're coming back to you on guardianship. And Lisa Wilson, thanks for coming back and being with us today. Today's meeting is being recorded. You will get an email. Anybody that signed up for today's meeting will get an email with the recording either later today or tomorrow. Your cameras and your microphones are muted, but we do welcome your questions. And if you have questions as we're going through the presentation, we're going to get through just as many as we can. Please just put your questions in the chat box. So having said that, Lisa, thanks for being here. I'm going to turn it over to you.
Okay. So I got interested in this practice area because I have a 33-year-old daughter with Down syndrome. So I use her for an example in a lot of my presentations. If she were here, she'd be shouting it from the other room, "Stop talking about me," but she's not. But anyway, over the 25 years of practicing, the guardianship laws have changed dramatically in the last few years. I guess it was 2015. So we are doing a lot fewer guardianships than we used to do. There's been this big philosophical, cultural, and legal shift away from guardianship. We used to do them as just a safety net. That was the general thinking. I think when I was first practicing, Harris County Guardianship Program used that term. Just put it in place as a safety net. Just take all your child's rights away as a safety net. That way, if a situation arises where you need that authority as guardian, you have it. Now, for some of our kids, like my own daughter, when I want to be my most flippant, I'll say, the day before she had all her constitutional rights taken away from her was no different than the day after. For her, it was meaningless that she was going to lose the right to drive, vote, get married. But for a lot of our kids, that is not the case. So it historically had always been a hard question of whether to pursue guardianship. Now it is a much harder question. So I will say that over the years, the areas where guardianship became the most compelling question were one in the medical arena. Now, a lot of times you can manage your child's care, and I'm going to use that term broadly. Child, I mean the relationship. We're no longer talking about a minor, really. We're going to talk about when your child with a disability reaches the age of adulthood or approaches the age of adulthood, 18. But I'm still going to talk about it as child. And I know that might not be the case for some of you that you're here for a child, but I think that's generally who my clients are. So I'm going to talk that way. But managing your child's care in the medical arena, sometimes that's challenging, although honestly, typically not, unless your child is suddenly in need of some procedure that is high risk. That can make a medical provider really uncomfortable. They need to get informed consent from the patient. And informed consent means a patient that fully understands that there is high risk with this procedure, but they're making the decision to move forward with full understanding in light of that risk. So from a medical provider's perspective, they've got to have either the patient that they are comfortable fully understands what's being contemplated, or someone with the legal authority to consent. The other arena that typically is also medical is more just the access to records, the management. I have had clients say, I couldn't even make an appointment with that specialist. They didn't even want to go down that path unless I was the guardian, unless someone could show up as guardian. Alternatively, I probably have had way more clients that have said, my child's had multiple surgeries. He can't consent. Nobody's ever questioned our ability. So a medical provider, they're going to be all across the board. You don't know what you might run into. You don't know what kind of health issues your child is going to face. But again, setting up a guardianship just as that safety net is really not anything we can do anymore. The third area that guardianship can become really compelling, unfortunately, is exploitation. And that's financial and that's personal. So financial, the circumstance I had with a client was she was, helping her adult son live more independently. And he was in an apartment and she'd visit periodically. And one day she shows up and all his furniture is gone. Well, he gave it to his friend. His friend really needed furniture. Then she realized that the friend was coming over on the 1st of every month when her son received his Social Security check, and he had not paid his rent for a couple months. Another attorney told me a story. I didn't have this as my case, where their client's son was working part-time, and there was a coworker, a young woman who had a real hard luck story. And so he bought her a car. Just show us your pay stub. He was working part-time at like a Walgreens. Just show us your pay stub, no credit needed. And suddenly he was on the hook for this car note. And of course, the young woman never showed up at work again. The car was gone. So those things being said, however, they're really rare. Part of that might be that our kids really don't have too much money as a rule. But I don't see that very often. I see it very differently when an elderly person loses capacity. Then it's almost like a guarantee somebody's going to come in and take advantage of that situation. But it's out there. It's a risk. It's something to be aware of. It's something my clients are really concerned about. What I mean by personal exploitation is there's been a couple instances I've been made aware of where someone will meet someone on the internet. And for a lot of our kids, just like any of us, they want acceptance, they want friends, they want that special someone. So they are not as aware of the risks as we are. And they may want to leave their house with someone that the parents think, it could be risky, or another caregiver thinks might be risky. If the child is an adult and wants to go away with this individual, there's really not much that a parent without any other legal authority can do. So that was a situation I had where my client, her daughter, did meet someone on the internet. He came and picked her up, and off they went, and wouldn't answer mom's phone calls for a while. Finally did. Mom stopped trying to control my life. Mom sent out law enforcement. Law enforcement said, yikes, but there's really nothing we can do. She's an adult. She doesn't want to go home. So I always want to caution my clients, like, I'm not saying that to scare you into guardianship, but these are some things that happen. Guardianship, in that scenario I just described, you could get law enforcement to remove your child from that situation, your adult child. So those risks are out there. They're not common. I mean, I don't have days full of stories like that. But I think what the current law, the current climate is challenging us to do is think of ways to protect our kids without taking all these rights away. So whereas we historically would do a guardianship just by going in with the doctor's evaluation, a form where the doctor had checked off what the child's functional limitations were. And if there were enough of them, we'd get the guardianship in place. It's not enough now to just say this person has a disability or this person is limited in their functioning in certain ways. We've also got to say there's absolutely no way we can support them in maintaining their autonomy and making their own decisions. By analogy, I've found it easier to make that understood by using an example of an older person. So my parents are in their 90s. They're really not able to manage things anymore. So my sister and I are going over there, making sure their bills are paid. We've got someone coming in 2 or 3 times a day, organize their meds, help them prepare their meals. We don't have to go to court and take all their rights away at first glance because they're starting to have some issues about their own decision-making. So that's kind of the frame of mind we want with our kids. Let's not take all their rights away, but how can we help them? Now that's interesting for our those of us who are parents, like we already are doing everything we can think of for our kids. We'd love for them to be autonomous and reach their potential and be as independent as possible. But anyway, that's the circumstance that we are in.
So Lisa, but there are some families. So I know that with the families that we work with, and I know you as well, the disabilities are all across the board, so we have some and their loved ones have, intellectual disabilities or IQs below 70. Some clearly their children don't walk, they don't talk, they don't, multiple disabilities, those types of things. So there are some there, I guess what I'm asking, isn't there some categories where it's just clear that guardianship is appropriate, but then are you speaking more of when it might not be appropriate, where, it's kind of on the line, where we might have somebody like high functioning autism, maybe they're immature for their age, we're still hopeful and optimistic, but they're not quite there yet at 18. Can you go deeper on that with us?
Sure. I mean, we still do guardianships. We still do a lot of guardianships, but we don't do them as just a matter of course when the child turns 18. There's a lot more thinking that goes into it. My daughter is extremely low functioning with a 45 IQ. For her, even if we entered into this process or this circumstance now with the changed law, guardianship would be absolutely necessary. No other services could support her in making her own decisions. That's just not feasible for her. So yes, absolutely. We still have a lot of people who do need a guardianship, but we are challenged to explore those possibilities. So it is the higher functioning individuals with autism that does seem to be that population that we are doing more of the alternatives. And I'll speak to what those alternatives are. So you basically have three avenues to go down. So the guardianship is a court proceeding, as Jackie mentioned. The result of that is that the child's rights to do certain things are removed. The rights that people get when they reach the age of 18, when they reach adulthood. As Jackie listed, right to get married, to vote, to drive, to decide where they live, consent and refuse medical treatment. Our law does allow for a partial or limited guardianship. Those terms are sort of interchangeable, where some rights can be retained, but that's pretty rare. And I think it's now because we have this higher burden of proof. We not only say, oh, this individual has Down syndrome, you know, they need a guardianship. Well, they have Down syndrome, but here's their other significant functional limitations. Not every person with Down syndrome needs to be under a guardianship. So we're going to look more specific at what their functional limitations are. And so it's very hard to argue that the functional limitations are so significant that they need to have rights removed, but then we want to allow them to retain a really significant right, like driving or marriage. So generally, again, even though our law allows it, it's pretty rare for us to do a limited guardianship. If we're going that route, if that's what's necessary, it's usually the whole thing.
What about taking this away later? So let's say a person, their child turns 18 and they're clearly not there. They cannot make these decisions for themselves. They do need guardianship at this time, but again, they're still hopeful and optimistic. The loved one is still maturing, and they do well. And 10 years from now, can we roll this back? If we have guardianship, can we roll it back later when they don't need it anymore?
Yeah, we have done full restorations and we have done partial restorations. It is not up to the parent to just decide we don't need this anymore. It requires really an identical process of removing the rights initially. So it's requires a doctor's evaluation. And what's different? You know, why is this a different situation 10 years later? We still have the, well, I'll go through the process later, but all the steps to create the guardianship initially have to go through, you have to go through to restore a right. I've done one where I restored just the right to drive, but that I'm not sure I'd be able to do again. I just think that, again, that's really hard to do in the current climate where you've got this heightened burden of proof to take someone's rights away and to allow the right to drive, or even to restore the right to drive, but leave all the other decision-making in the hands of the guardian. So the right to drive used to be a really big issue with clients on whether to move down that path on guardianship. And so I think for a lot of clients who that is still really important, then some of the alternatives become a better choice, at least to explore that for those first years after the child turns 18 to see how far they will progress. So typically for our kids, we're doing guardianship over the person only. There is such a thing as a guardianship of the estate. Most of our kids don't have an estate unless like a relative died and they inherited something, then sometimes that forces the creation of a guardianship of the estate for someone to have the legal authority to manage. But typically we're just doing guardianship of the person, which gives the guardian those rights to care, custody, control, decision-making in a lot of respects, a guardianship kind of recreates the parent-minor child relationship. Third parties have to go through the guardian for a lot of decision making. So again, guardianship is one track to consider. Court proceeding, your child's right to do things, to contract, to sign anything, to the other things that were mentioned. So those rights are gone, and some of them are placed on the guardianship. Obviously, the right to get married, that can't be a guardian decision. That's just way too personal of a decision. But generally, someone under guardianship is not able to get married. So the other track to consider, and Allison, I think here you can slip to the next slide, and that would be, so a power of attorney. So a power of attorney is a document that you would sign that says, in the event I ever need someone to make decisions for me, or for financial matters, maybe just to be the extension of me to handle the mechanics of paying my bills or accessing my accounts or filing my tax returns. So you can name an agent that should act in the same manner you would in your own best interest, but they're like an extension of you. And it generally doesn't take away your right to do anything. So as we're contemplating our children in that situation, if they signed a power of attorney and identified someone to act as their agent, they still have all their rights. They could change their mind and revoke the power of attorney. They could still go, move their money to a different bank. They can still handle anything as they could previously to signing it. A financial power of attorney can be made effective immediately. So I named my husband on to serve as my agent for financial matters. If I'm recovering from surgery and there's fraud activity on my credit card, I want him to be able to just handle that right away. The medical power of attorney is very different. The medical power of attorney, no agent is going to have any authority until your doctor determines you are now incapacitated and you no longer have the ability to make your own medical decisions. So there's a presumption that the person signing had full mental capacity to understand the legal document, have the ability to sign a legal document, and therefore it's a valid legal document. So the next day, the parent really doesn't have the right to make medical decisions if we're moving forward on the presumption that this person had enough capacity to execute a legal document. So the financial power of attorney, medical power of attorney are kind of very different that way. So the third route to contemplate, and that would be the next slide, Allison. Yeah.
Can we stay on power of attorney for just a second? Sure. Before we move on to the supported decision making? So one of the key things that you said that I think is important to note is that, so if you have a power of attorney, a healthcare power of attorney, and your child had the capacity to sign it when they turned 18, your adult child had the capacity to sign it. Again, they have the right to revoke that at any time. So if we have kids that are oppositional or have, the teenage syndrome lingering that we all go through, that could be problematic. So that's one thing that I wanted to mention, but that's not any different than anything else in life, honestly. But the other thing on the power of attorney and healthcare power of attorney, and I know that we're talking about special needs here, but I always just like to chime in here and say, this is, if you're taking notes, make a note to yourself to check on your own power of attorney and your own healthcare power of attorney. And if you have aging parents and you haven't looked at this lately, or they haven't looked at this lately, you want to check on this for your aging parents too, because it's a lot easier to have this in place and everybody knows it's in place than somebody has a stroke and it's not in place, or there's big decisions to be made and it's a problem. And then the last thing that I want to say is I am a big fan of parents that are sending their kids off to college to have this as well. Car accidents, other things that happen, they're in the hospital, in college, out of state, or 5 hours from here, or whatever. Guess what? If you don't have this healthcare power of attorney and something happens, you're going to be hard pressed to get any information. And so those are just a few little tips on that. That it's just something that we put on the shelf. We don't think about it all the time, but since we're talking about it, I just want you to put that on your to-do list to check it out.
Okay, yes, good thought, good advice. So the supported making agreement is what the legislature gave us at the same time they changed the law about guardianship, when they established, the additional requirements to establish the guardianship, about looking at other feasible supports and services that could support this person in making their own decisions. They gave us the supported decision-making agreement as something to consider as an alternative. So the supported decision-making agreement, to be distinguished from a power of attorney, is it does not allow the individuals named, they're called supporters, to act for the child, or here, what I'll call the principal, the person signing it. So the principal would say, would indicate on the form that they may need help in certain areas, and it'll list financial matters, finding a job, school, my health care, my mental health care. So they can say, I may need help in these certain areas, and I'm identifying these individuals named as people who can support me in my decision making. So it really is a release of information to third parties, allowing them to communicate and release information to the named people in the document, typically parents, sometimes an aunt and uncle, sometimes older siblings. And so the document kind of describes that the supporters then would gather the relevant information, go back to the principal, and help explain in language that they could understand, here's your choices as we see it. And the individual, the principal, makes their own decision. And then if necessary, the supporters would communicate that decision back to the third parties. So again, the supporters don't have any authority to sign, act, make choices on behalf of the principal. So when it first came out, we all were like, well, what does it do then? But I've used it a lot. I mean, my clients have. I've prepared it quite a bit for them. And I think it does what it was intended to do, and it allows this decision-making to be an effort where the family can really support the person in making these decisions. I haven't had anybody come back and say, well, that didn't work. It's a document that kind of cites the statute. We are told that Texas is the only state that has anything like this, although I have seen people come from other states that are court-appointed advocates, which is different from a guardian. So I think other states are kind of exploring this issue as well, without removing someone's rights, but allowing some trusted person to be involved in decision-making. So
I've got a couple of questions.
Yeah.
Go finish that thought, and then we'll go into those questions, please.
Well, I was just going to say that typically, if I determine that my client or my client's child has enough understanding to understand this document, they typically are going to understand the basics of a power of attorney as well. So we almost always are doing that as a cluster of documents. As an alternative to guardianship. Let's do the supported decision-making agreement, but let's also do the power of attorney, so that if you need somebody to actually access your bank account, they've got the clear authority to act on your behalf. And then the medical power of attorney, again, is there should something traumatic happen to the individual where a surrogate decision maker needs to be in place for medical treatment. So we typically are doing all of those together. So go ahead, Alice.
So basically, and if we're not doing guardianship, the recommendation is a power of attorney and the supported decision-making agreement, which takes me to one question. I was just going to ask, what do you suggest? So some families have children that are going to be, or adult children that are going to be staying in the public school system. There's IEPs, there's 504 meetings, there's ARD meetings, Um, basically, if they have the power of attorney and supported decision-making agreement, then so with the power of attorney, they can still make education choices for the individual. Is that, can you talk about that? Because we see a lot of families in that situation.
To me, that's the sweet spot of the supported decision-making agreement is the school. Because the adult child who executes the supported decision-making agreement, they're basically saying to the school, these are complicated decisions. I need help of the family members that I love and trust. Here they are, talk to them. They're gonna help me make my choices. I think if nothing else, the supported decision-making agreement is perfect for that. I've had so many clients come to me over the years that say they've been told by the school they have to get guardianship, or their child will sign themselves out of school. And I thought, really? Well, actually, I had a client who did. Their child did, so we had to get guardianship to get them back enrolled. But I think it's perfect for that because, they still, depending on the child, depending on the functional level of the child, but let's involve the parents. Let's not have that be an absolute exclusion because they didn't get guardianship. But yeah, here, bring them in. Child's still going to decide, but they get a lot of information, a lot of support from the parents.
For sure. A few other quick questions. Does the supported decision-making agreement require an attorney to be executed?
No. And I really like to make a point that these forms are out there. Disability Rights Texas.org. It's drtx.org. Check it out. They are not supportive of guardianship ever, I think. They have a lot of great information there about these documents, and they have the documents. And I try to make a big point of telling people that, even people who come into my office, like, I'm happy to do those documents. We charge, I think, $450 if you do the whole cluster. But I like to tell everybody it's out there because I really think that's the spirit of the law, that these families don't have to go through the court system or come to an attorney. Now, some of my clients have said they really want their child to come into my office and sign, because then it's not something that the parents are making them do, that the child can feel like they have their own counsel. I can talk to them about it. I can tell them, what it means. And so they want their child to have that experience. And so I'm happy to do that. But again, it's out there. And again, there's great information there. The documents are there. I think they all just have to be notarized. So
this is true for supported decision-making agreements and power of attorney. But do you recommend doing it yourself? I mean, can you even do it yourself? Guardianship, special needs trust, some of the other matters our families are faced with?
So guardianship, I heard of a court once in Texas that allowed somebody to represent themselves on guardianship, but most of the courts I deal with all around the Houston area and even occasionally up in Austin or someplace else, they require a guardian to have an attorney, because the way it's put is that the guardian is not really representing themselves. They basically are going to step into the shoes of the child. And so they're not really just representing their own interests, which you can do if you're pro se on a contract dispute or something like that. So my understanding is in Texas, any guardian has to have an attorney. I know when I've had guardianships that became contested, the court is basically, if somebody calls the court, I want to contest this, the first thing is you got to get an attorney. You know, again, you can't represent yourself in a guardianship matter.
Okay, one question, this is going to be a great question for you, Mom, with a child with special needs. Having full guardianship versus limited guardianship, does that impact SSI benefits?
No, really, guardianship and benefits are totally unrelated. They really, you know, the way I heard it put when I was first practicing is generally there's no requirement for government programs to require someone have their rights removed to be eligible for benefits. So it's just a matter of who signs the forms as they come in, who signs the authorizations, that kind of thing. The other thing that kind of makes me think of is if you go guardianship versus power of attorney versus supported decision making, you're going to be met with a public out there and even entities that you think should know better, and they're going to have no idea what you're handing them. I have clients that call me that we've gone through the guardianship process with their kids, and they say, oh, well, you know, the insurance company said I needed a power of attorney. I'm like, no, your child's been judicially declared unable to execute legal documents, and that's why you have guardianship. A guardianship way trumps any power of attorney. I've had doctors look at me, not doctors, staff, front desk person, when I've handed over the guardianship letters, and they'll say, well, we don't really understand why you have this because you're the mother. And I say, well, you know, just make it part of her file, because someday I'll call up here to have her records sent somewhere, and your custodian of records is going to want to see some authority. So have that be part of the file. So, you know, you just never know what you're going to run into. And then you put the supported decision-making agreement out there too, and people don't really know what they're looking at or what the difference is. So
one thing that I will comment on in working with the Social Security Administration, they really don't care about your guardianship, power of attorney, supported decision making. It doesn't matter. They have their own forms. So you can be the representative payee. There's different forms. They have form numbers. So like some parents, they're not the representative payee, but their child, honestly, Social Security Administration is hard to understand. It's no match for an 18-year-old that doesn't have cognitive deficits. So, but there is a form. So even if you're not the representative payee, where you are authorized to call and interact, you know, with your child. And so they don't want your documents, just so you know. Yeah. So they matter in other places, but not at the Social Security Administration for whatever reason. Okay, so we have a question. If a child at 18 does not understand any of this medical power of attorney, or it basically won't help a parent, so as an attorney, you can't sign off on something if the person signing, the child that's turning 18, does not have the capacity to understand what they're signing, then basically the power of attorney is off the table, right?
Yeah, I tell my clients I have to kind of reserve that right. If I haven't previously met their kids, you know, a lot of times we'll have a meeting ahead of that, and I'll just start off by talking with the kid about school and what they like to do. And then we kind of work our way around to, you know why you're here? You know, why are you talking to a lawyer? And if I feel pretty comfortable that they're going to understand the basics of, I'm going to need some help, I trust my parents, you know, to make these decisions, you know, I'm pretty comfortable with that. I mean, I've been asked to do affidavits from time to time that the person who I prepared documents for had the capacity to sign them. And of course, I always say, well, of course, or we wouldn't have done it. But and of course, I'll look at it a little differently if somebody comes in and they want to name their new best friend versus, you know, their parents who maybe I've had a relationship with, and, you know, that kind of thing. So it's a little bit of a judgment call, but there's gotta be a basic understanding of that. If they're totally unable to, then I've had to say, we just can't do this. We really can't do this. So, okay. So I can run through quickly the procedure for if we decide to go the guardianship route. It's way more involved than people expect it's going to be. And it's real frustrating for my parents, because my clients who are parents, because of course, they've always wanted to do what's best for their kid. And this is a real challenging process for them, because there's, first of all, a presumption that their child is perfectly competent. And there's a bit of a presumption that they're not really the best people to serve. I guess that's sort of a stretch, but they have to go through a criminal background check. So the process, I try and remind them, it's built around due process protections for their child, because the result of this process is so extreme. These rights removed, these rights that we all have that are so basic to our freedom and our liberty and our choice making. So again, I try and compare it to an aging parent. How if they make one bad decision with their money, do they want their adult child to suddenly be in charge of all their assets? Hardly. So there's a lot of due process protections for that parent so that that doesn't happen. It's not just one bad choice, one mistake. Well, it's the same for our kids. They may make bad decisions. The advocates who got these changes in place with the legislature and the supported decision-making, they were self-advocates, people with disabilities speaking to the legislature themselves or through Disability Rights Texas. And that was kind of their point. Everybody makes bad decisions. Do we have all our rights taken away because we might make a bad decision? So anyway, so the process again is working at protecting these rights. This is not taken lightly. So the doctor's form, there's a standard form that the judges around the state have all agreed this is the best form to use. It has all the information that the statute requests to be able to move forward. Any doctor can fill it out. It's got to be within this 120 days of the filing date to start everything. So they want a snapshot. What are your child's functional limitations right now? You can start the court proceeding as long as you're within 6 months of the 18th birthday. I get calls all the time where people want to come in when their kids are 16 because they heard it takes years. It doesn't. It takes about 3 or 4 months, but 6 months is the earliest you can start. And also the process is no different no matter what the age of the individual going under guardianship. I've had parents get guardianship of kids in their 40s and 50s because something happened. Or sometimes parents will cook along making decisions for the child, but when the parents are gone, siblings, somebody's got to be selected as the person who has the clear authority for decision making. So age doesn't really matter as long as we're talking about an adult or someone about to be an adult. So we prepare a petition that has very basic information, application. Person lives in this county where we're filing, so it's the appropriate jurisdiction. They need help taking care of themselves. Feasible alternatives aren't really available. Usually, again, there's no guardian of the estate. We're doing guardian of the person. We need to list the family members, immediate family, a couple other things. So that gets filed. The first thing that happens is the constable has to serve your child and go out and hand them a copy of that petition. So again, the due process, what makes this case different from a typical lawsuit, the petition has to be sworn to. Parents have to say everything in here is correct. Law enforcement has to serve the citation. Other cases we can get, anybody over the age of 18, they can serve it. But all these due process protections. So they get served a copy of the citation. The officer does an affidavit that they personally handed it to the child at such and such date and time. That goes with the court's file, becomes part of their record. Okay, so the next one, Allison, the next slide will talk about the next step. So there are certain individuals that are required to be given notice of the guardianship. So again, very different from any other lawsuit. where like we have to let adult siblings know someone's trying to get guardianship over your sister. You need to be aware of this. You have the opportunity to object or otherwise. In some of the more densely populated courts, Harris County, Montgomery County, Galveston, not Fort Bend yet, surprisingly, but I'm sure that's going to happen. The courts are required to have a court investigator. That typically is someone with a social work background. They're going to get assigned to the case. They're usually on the court staff. Historically, they would meet with the family. Now everything's Zoom. But their job is twofold. One is to just kind of verify there's no need for a guardianship of the estate. Person actually lives here in this county. And then they're going to make a recommendation to the court. Yes, it appears that this is appropriate for a guardianship to move forward. Then the court appoints an attorney to represent the child. And that attorney's job is to try and explain to your child what's happening. And that, of course, will depend on the level of understanding of the child. But, you know, they should explain, you're going to lose your right to get married, to drive, to vote. How do you feel about this? Do you want this to move forward? And it again, just depends on the understanding of the child. So the attorney ad litem's job is to determine how the child feels about the process and represent that to the court. Now, for a lot of our kids, again, using my daughter as an example, she just wanted to hug the lawyer when the lawyer came by. They didn't really have too much of a conversation about the rights being at risk. And the attorney ad litem, her report to the court was kind of along the lines of, you know, I visited with Leslie in her home. I don't think she really understood the process and couldn't really express an opinion, but she's clearly loved and well cared for. I think if she could express herself, she'd want her parents to continue to make decisions on her behalf. So it may go something like that. It may go something like, Leslie was really opposed to the guardianships. She said she doesn't want her parents making decisions. She wants to go live with her sister who lives in Austin. That can happen too. That doesn't mean we all shrug our shoulders and go home and we're done. We still have a lot of evidence that this individual needs to have a surrogate decision maker appointed. But again, as part of due process, that individual has the right to have their opinion heard in the court. So the parents applying have to go through the criminal background check. That is new. It used to be non-family members didn't have to go through a criminal background check. Apparently enough bad things happened that the legislature changed that. They have to register online statewide to be guardians, and they have to watch a little training video and get a certificate that the court will get, and you know, it's part of their checklist that all the requirements have been made. So once all those pieces come together, then we schedule the court hearing. Those two right now are being done by Zoom. I'm not quite sure how that will how long that will continue. So at the court hearing, generally the court staff has already looked at everything. There typically aren't any surprises. The hearing would be scheduled on an uncontested docket unless someone did contest the guardianship. It could be contested by saying the person doesn't need to be under guardianship, in which case they'd have to come up with controverting medical opinion, generally, or that the person that is applying is not the best to serve. So the hearing is usually pretty brief, pretty rote. Parents get appointed. To qualify, they have to take an oath and pay a bond. Bond is usually pretty minimal. If there are no assets that the guardians are managing, then it's usually just a one-time cash payment. The guardianship does have to be kept current by filing an annual report. And that is, it's a page and a half, fill in the blanks, circle the answer form that gets mailed into the court with a $12 filing fee. That's all you have to do to renew it. It's not much, but the courts take this very seriously. They need to know you're still there. They need to know your child is still within their jurisdiction because the judges are personally liable to the wards. They need to know that you're still alive and capable to be serving as that person's guardian. So, again, basic information, $12 fee, get it sent in, but it's critical. The judges check that. If they don't get it, you're going to hear from them. Usually they'll send a letter, you're late, get it in by this date. If you don't, you're going to get served by the constable. You need to show up in court or you'll be removed and somebody else might be appointed as guardian. So we charge a fixed fee of $4,000 to do guardianship of the person only, parents seeking guardianship of an adult child. With the other fees, I tell people to expect it to be between $5,000 and $5,500 altogether. Co-guardians in Texas can be appointed, but only if they are husband and wife or joint managing conservators in a divorce decree, or if they were appointed in another state and then the family moves here, that they can continue to serve as a co. So
what about guardianship? If you moved here from another state and you have guardianship from another state, and what if you move into a different county in this state? Can you tell people what happens or what needs to happen for that?
Sure. Yeah, it's as long as the guardianship is current, you haven't let it lapse, it's very easy to move. Super easy to move it from county to county within Texas. We basically get a photocopy of the file from the original court, send it over to the new court, and then your due date typically stays the same for your annual report. From state to state, it's a little more complicated, but there is a uniform code that a lot of states have adopted. So we've done numerous transfers of a lot of different states, and the process is usually very similar amongst the states. We usually need an attorney at each end to kind of close up one and start the other, but it's generally pretty easy to do. The guardianship needs to be where the child resides, because that's who the court is responsible to.
I know we had that question. I called you on that question last week because we had a mom who lived in another state and her child was living in a facility here in Texas, and so she had guardianship in the other state, and that was the question. So thanks for clarifying that. We have just a few minutes left, Lisa. One question that comes up, I'm going to give two questions. So I know that you talked about people getting notified. So what if we have a parent that is missing in action? What if we have a parent that is like in a divorce situation that is absolutely opposed to this guardianship process that the mother or father is seeking, whatever? And then what if we have a parent, one parent, so one parent's here with the child and the other parent is out of the country? How do we get them? What happens with this?
So if it's a parent that is not present and easily notified or brought into the process, you're required to give notice. And so, my clients always say, oh, well, he hasn't, been in contact with us for 15 years. And it's like, unfortunately, the statute just says, parents need to be given notice. It doesn't say parents who've been good parents or parents who have, maintained communication. It's just, that's a requirement. So we do kind of whatever it takes. We try to, the family, usually it's going to come from them. Do you know dad's sister? Can she reach him? How do we do this? We just kind of try to do whatever we need to do to get that person acknowledged or served. Now, if worse comes to worse, and it depends on the court, sometimes we can go to the court and say, here's all the things we've tried. We just can't reach that person. They may move forward. Other courts may require the appointment of an attorney ad litem to represent dad who can't be found. So it kind of depends on the court. The question about if another parent wants to contest the guardianship. So if a guardianship, if another parent thinks the child doesn't need to be under guardianship, and we've already presented pretty compelling evidence that, you know, their functional limitations are significant, that they can't really manage their own affairs, then they've got to present contrary evidence. They've got to, again, get an attorney, maybe request an independent evaluation by another doctor if they think another doctor is going to give a different opinion. So they've got to present some evidence otherwise. And the other thing that comes up a lot is, so in the parents can be co-guardians if they were divorced and named joint managing conservators in child custody decree. And if both parents want to be guardian, my experience in the guardianship courts is they're going to do that. Because they say, you've already worked through all of that in the other court, and that court determined that you two can co-parent and share that responsibility. We really don't want to have all that again. Now, if there's truly a reason why it would be detrimental, harmful to the child to have this other parent who, you know, involved, then it becomes a contested guardianship. Then maybe that evidence, because ultimately the court's decision has to be best interest of the child. And so that's what's going to be weighed in front of the court.
And that physician certificate's really going to hold a lot of weight too. I mean, and a child that's had a long-standing relationship with a physician, and the physician has all this background and stuff. So hopefully that won't be your case where it's contested or, you know, it's adversarial. But I've definitely heard of that coming up, and I know that's a question that comes up almost every single time on these. So let me just see. I think we had one more, and I think let's see. So we answered the question about renewing the guardianship. And someone asked about a power of attorney. Does that have to be renewed, or is it good until it's renewed?
No, generally they're good forever. Now, if somebody comes, you know, if I've done estate planning for someone and they come back to make a few changes to their will, they'll say, let's go ahead and update all your powers of attorney. Historically, banks would give clients a hard time if they came in with an old power of attorney, which to me they shouldn't. You know, if I did my power of attorney now and 15 years from now I'm in a car accident, I would want my agents to be able to step forward. But oddly enough, banks would want something really recent. And you know, it seemed to me, well, maybe you should be more suspect of a brand new power of attorney that somebody's walking.
Right.
But they wouldn't take, like the bank I banked at, they said, oh yeah, we don't take them if they're more than 24 months old. And I thought, well, that's crazy. You wouldn't expect everybody to redo their estate planning every 24 months. So it was kind of a bad situation where they wouldn't accept powers of attorney for the purpose for which they were put in place. So the legislature came out and said, okay, you can't make up your own rules about 24 months. You're not going to take them, banks. You have to take them unless you really suspect there's a fraud. And then you need to take these steps to report that fraud or do something about it. So again, the way communication travels on these issues, my clients are still getting kickback from banks where they'll look at a power of attorney and, well, you know, it meets all the statutory requirements under Texas. Well, I'm not sure. I don't know if we can take this. So it can be a problem. So when the opportunity presents itself, I would say update them if they're getting too old, but there's no expiration for them. Same with the medical. I mean, they should be good.
Yes, thank you. Thank you so much, Lisa, for presenting today. You always do such an amazing job. These are just some bullet points that we say should be on your special needs planning radar. We have other webinars that talk about all of these things. And so you can reach Lisa. Lisa's contact information is here. We have our Facebook page and our YouTube channel. All of our webinars are uploaded to our YouTube channel. And again, for registering today, you will get an email with today's recording. So I would just like to thank everyone for being here today. I got 1 o'clock, so we're gonna wrap this up. And thank you again, Jackie, for having us. And we'll be happy to be back with you again soon. Thanks so much, everyone. Happy Friday. Take care.
All right. Thanks for the opportunity.
All right. Bye now.
Bye.